U.S. Supreme Court today ruling against the state of Hawaii's default ban on carrying firearms in public places. Now, the so-called vampire rule in the case Wolford v. Lopez was the focus of the challenge. Hawaii's law bans carrying of firearms on property open to the public, like grocery stores, restaurants, gas stations, and more, unless the owner posts a sign stating that carrying is allowed on the premises. Now, the Second Amendment Foundation says prior laws permitted lawful carry in businesses open to the public unless the owner affirmatively requested that guns not be carried. Now, the flipping of the default situation from allowing guns unless denied to banning all guns unless invited created a de facto public carry ban that Second Amendment advocates fought against. And today, the U.S. Supreme Court held that Hawaii's law violated the Second Amendment. Now, prevailing justices, they reiterated their prior rulings on the Second Amendment that a court must determine whether the law being challenged clashes with the plain text of the Second Amendment, which reads, "A well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed." Now, if a challenged law falls within the plain text of the Second Amendment, Justice Alito said, it is presumptively unconstitutional. We'll have more on that story at thecentersquare.com. Meanwhile, yesterday, the Tennessee Court of Appeals heard a case that could decide if a ruling declaring 2 Tennessee gun laws will stand. The Center Square Associate Editor Kim Jarrett reports the Tennessee laws prohibited carrying firearms in state parks and carrying a gun or club with the intent to go armed and use it for violence or aggression. Now, a 3-judge panel of the Gibson County Chancery Court said that the 2 laws were unconstitutional, void, and of no effect back in August of 2025, which the state appealed and the Court of Appeals heard Tuesday. John Harris, representing the Gun Owners of America and others, said he believes the 3-judge panel had the inherent authority because it's separate and independent. He argued the law is unconstitutional.
These rights were infringed when the legislature exceeded its constitutional boundaries by enacting a statutory scheme that criminalizes by default all the conduct subsumed within the scope of those constitutional protections. Those statutory schemes make it a crime for every person at all times in all places within the state, including their own homes, to possess a firearm for the purpose of being armed. The unanimous 3-judge panel declared the legislature's statutory scheme to be unconstitutional and void.
Now, the court didn't indicate when it would make a decision on that case out of Tennessee. Meanwhile, litigants are in Virginia federal court today in an attempt to block Virginia's ban on certain semi-automatic firearms and public carry restrictions. The laws signed by Virginia Democratic Governor Abigail Spanberger are set to take effect July 1st. And in other litigation, there's been no movement on the case challenging Illinois' gun ban. That law was put into effect in 2023 and challenged all throughout the judiciary, going up and down back to the 7th Circuit Court of Appeals. That case awaits a ruling on that panel, which heard the case back in September. Another Illinois case, a federal lawsuit against the state's firearm owner's ID card, the state requirement for individuals to have a state police-issued identification in order to buy or keep firearms and ammunition. State defendants there, they motioned for an extension to respond to the lawsuit, and the judge granting that for July 13th. We'll keep you updated on the latest regarding the Second Amendment and challenges in the courts. Get the headlines at thecentersquare.com.